Good night, Professor. Thanks very much for your presentation. I appreciate it a lot. As a matter of law, we've seen the example in the United Kingdom where there's been a steady progression in the rights of homosexual people from decriminalization in 1957 to civil partnership in 2004. I think 2 years ago there was the Same-Sex Marriage Act that was passed, right?
Last year, 2015.
Last year. And that progression, and particularly the period between 2004 and 2012, saw a steady debate about the place of religious actors within the society and how they're going to interact with a new subspecies within the society that are totally autonomous, that are equal in every way and form to get married and to live their lives as people without any kind of special characterization or discrimination. But we've also seen cases where persons who have beliefs that we've seen expressed today that do not necessarily concur with this forward-thinking notion have been penalized for holding their views, particularly in public functions. How do you think, as a matter of policy, do we balance this so that people can express their religion without fear of discrimination, and people can be homosexual without fear of discrimination as well?
I think the balance has already been decided in anti-discrimination law that already existed with regard to race and sex in particular. I've actually got an article coming out in March in the Modern Law Review, so it'll be online. The title is Accommodating Religious Beliefs, and the subtitle is Harm, Clothing or Symbols, and Refusals to Serve Others. And what you'll see, what I argue is that religious clothing and symbols generally cause no harm to anyone else and should be accommodated. So I support the judgment of the European Court of Human Rights in the Ouida case in favor of a Christian woman working for British Airways as a check-in agent, London Heathrow Airport. She wanted to wear a visible cross. I also support the right of Muslim women to wear headscarves, Sikh men to wear turbans, Jewish men to wear skull caps, etc. But when it comes to refusals to serve people because of their sexual orientation, race, religion, etc., there I draw the line. I say this is something that harms another person, and essentially the individual has to choose between their beliefs and this particular form of employment. I suppose the only consolation I can offer is that perhaps the individual can reflect on whether or not they are really condoning sin. So we have the case of Lillian Liddell, the registrar at Islington Town Hall in London, who said she could not perform civil partnership ceremonies because she would be condoning sin. Well, she was only being asked to do her job, and the job was essentially the same as what she did for a different sex couple having a marriage, and it was not a religious marriage ceremony. It was a completely civil ceremony. So she put the interpretation on it that she was condoning sin, and unfortunately that meant she had to lose her job. But the problem is, if we allowed her an exemption, there would be no limit to it. So Lillian Liddell's a black Christian woman. She benefits from anti-discrimination law. It's a package deal. So if a white man working alongside her said, no, I cannot serve black people, I cannot serve people, I'm Christian, I cannot serve Hindus, etc., etc., there would be no end to it. We have a huge hole in our anti-discrimination laws. Any religious individual could say, no, 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 this offends my beliefs. So that's why it had to be rejected. But the exemption that is strongly established is that religious organizations do not have to marry same-sex couples. So that's where the line is drawn. She was working for the government in a public sector job.